Welcome back to Late Night Review. In today's episode, we will be reviewing Trial Day 29. We will finish testimony of Irene Scorbello, Brian Loughran, and Marie Russell. We start out the day today with pictures of John post-mortem, and Dr. Scorbello reviews these pictures and explains what she saw or noticed within these injuries. Now, there were more pictures shown to the court, but they were not displayed for us to see. She was asked if the injuries to John's head could have been a result of being hit by a car and then thus hitting his head on a curb, and she said yes, that could be a possibility. Lally asked her if the injuries that she observed, if they are consistent with injuries observed in other cases that she's seen of a pedestrian being hit by a vehicle. And she said, quote, "They're not the classic pedestrian injuries that we observe, no." End quote. She also described that when a person is hit by a vehicle, that there's often damage or injuries to the lower extremities of the body, so the legs, from the bumper hitting them. And she did not observe any injuries on John's legs. Miss Little did the cross-examination on Dr. Scorbello. She started out asking her questions, about reviewing basically testimony from yesterday about a blunt object and what that would look like. Miss Little asked her if the injuries could be a result from being hit with a baseball bat, and she said yes. She gave the example of a dumbbell, and she said yes. And yes, even a German Shepherd's claws. She said she also observed a number of injuries on John's face, his arm, and his head.
Let's take those one at a time. No injury whatsoever to his shoulders.
Correct.
No injuries whatsoever to his chest area, aside from sort of the CPR-related injuries that you discussed.
Yes, correct.
And that was in the sternum, is that right?
It was in the ribs, just adjacent to the sternum, yes.
Okay. No injuries to his torso, other than that?
No.
No injuries to his back?
No.
No injuries to his hips?
Correct.
No injuries to his pelvis?
Correct.
No injuries to his thighs?
To his...
Thighs?
No.
No injuries to his knees?
Correct.
No injuries to his shins?
Correct.
No injuries to his ankles?
Correct.
No injuries to his feet?
Correct.
From the neck down, he did not have a single broken bone, again, aside from those CPR-related injuries you discussed, correct?
That's correct.
Not a single fracture.
Other than CPR, correct.
And you spoke earlier about how the bumper was a little higher than on, say, a regular sedan, correct?
Correct.
And so usually in a pedestrian collision, you would see injuries to the knees. Is that right?
Objection.
I'll allow it.
Depending on the kind of car, depending on the speed, depending on the height of the individual and the car, you might see injuries to their lower extremity. Yeah.
But in this case, you didn't see any injuries to his thighs, to his pelvis, anything even at the height of the bumper. Is that correct?
Correct. At a very minor abrasion to the side of his right knee.
Would you agree that John O'Keefe's injuries, or lack thereof, are inconsistent with having been struck by a vehicle at 24 miles per hour?
I would say it's likely and unlikely at the same time, depending on the position of the body and the vehicle in question.
His arm did not have any fractures on his arm, as well as no bruises. They showed a picture of John's face, but not to us. The injuries to his face aren't from blunt force trauma. She also agreed that being punched in the face could result in those type of injuries. His tongue also had an injury, which she also agreed could be the result of being punched. She also described that the skin on the back of John's head was scratched and agreed that it could be from dragging the victim. Miss Little asked her about her comment yesterday about usually when she sees signs of an altercation, she sees broken nails or fractures on the knuckles or even cuts. Miss Little asked her, are these the only signs that you see as injuries from an altercation? And she said no. So just because she didn't see them, it doesn't then rule out the possibility of being in an altercation. After Dr. Scardi-Ballo finished her testimony, the Commonwealth rested their case. Mr. Jackson's defense case begins with a motion for acquittal for counts 1, 2, and 3. Mr. Jackson asked for 10 minutes for his argument. He basically said that based off of the evidence that the Commonwealth put forward in the trial is insufficient for a reasonable jury to meet such a finding for beyond reasonable doubt. And no reasonable or rational jury will be able to come to a unanimous verdict in favor of the Commonwealth. He also believes that they had no actual competent evidence to prove Karen's vehicle actually hit John O'Keefe and have only shown speculation and conjecture for their evidence. Lowley then said he believes that their case does not hang on Trooper Paul's testimony and that all of the witness testimony is proof, including the GPS evidence. Judge Beverly said she denies the motion. So with that, we begin with the defense's witnesses. Mr. Iannetti calls his first witness to the stand, and that's Brian Loughran. Brian said he's known the Albert family since he was a child in elementary school and also worked for the Albert family at the pizza shop for 8 years. His relevance in this case is that he was the snowplow driver that plowed 34 Fairview on the early morning of January 29th. He said that he actually passed 34 Fairview at 2:45 a.m. and was able to see the entire lawn, even up to the door of the home, and that he did not see anything in the Albert's front lawn. He also explained that he has to pay attention to what's going on around him as he's driving because there could be pedestrians or animals, and he has to pay attention to make sure he doesn't hit any of these. So he was particularly paying attention to the Alberts lawn. And not to mention, he knows that the Alberts live there. So I would say, as most people do when they drive past someone's house that they know, they generally do look in that direction. But for Brian specifically, he has to pay attention to these type of things. And he said he did not see anything in the Alberts front lawn, even by the flagpole. He also said he passed 34 Fairview again that night around 3:30 a.m. And at that time, there was a Ford Edge parked out front of their yard by the flagpole. He said the Ford Edge stuck out to him because the Alberts never park vehicles on the street in front of their home. And apparently parking a vehicle on the road in Canton, I don't know if it's just Massachusetts in general. I guess there's some type of law that prevents you from parking out front, like by the curb in front of your home, because of the snowplows that have to go through there. And he said that they actually have policy where they are to call in to their supervisor to tell them there is a vehicle parked out front of this yard, and then they contact the police, and the police contacts the owner and tells them to move the vehicle. He said he didn't call in to his supervisors to tell him to get them to move that vehicle as a courtesy to the Alberts since he knew them well. And he said during that pass, he could not see as much of the Alberts front lawn because of that Ford Edge parked there by the flagpole. He said in about 3 hours later that he went to pass by the house again and couldn't because of the first responders blocking the road. I don't know if you remember back to one of the previous days, I can't remember what trial day it was. This witness that supposedly they changed their story and they didn't feel it was credible at that point. So his story went from they saw the vehicle there from Cedar Crest Road, which was some distance away in a blizzard, as Tully pointed out. But their vehicle size has to do with anything of credibility. I don't know, because I don't see a reason to discredit a witness because it's snowing and they're in a larger vehicle. So apparently this is the witness that all of that was described about. So Brian is colorblind, and he described his color blindness that he can see colors. It's just the different shades of the color. He can't really tell the difference. He can't really tell apart. So it's not that he can't see color. It's just the variance in the colors is where he has the difficulty. And he also said that when Paul went to question him, because he went over to an ice skating rink to meet him, and that he told Paul that he had saw a Ford Edge out front of the Alberts lawn by the flagpole. And so Paul wanted to be sure that that's what he saw. So they went outside to a parking lot and had him point out a Ford Edge, which he did. When Mr. Lally cross-examined him, he tried to say that he did not say it was a Ford Edge until they had went out to the parking lot. But Brian insists that he told before they ever went outside to the parking lot that it was a Ford Edge. And that was the end of testimony with Brian. And the next person that Mr. Yannetti called to the stand was expert witness Marie Russell. If you remember from day 27, she was one of the experts that the Commonwealth was not wanting to testify. And Judge Beverly did find those findings that, yes, there was a violation in Rule 14, but that she was going to allow Dr. Russell to testify within certain things. So this is Marie Russell. She was shown a picture of John's arm, and she said she believes that those type of injuries are from dog bites. If you didn't check out day 27, please do. I give the credentials and where Dr. Russell gets all of her information and her studies and expertise on dog bites. When Lally was cross-examining Dr. Russell, Miss Beverly showed a different side of herself that I didn't know was possible. But she was very irritated with Lally because he continued to ask a question, and then as Dr. Russell would try to answer it, he would interrupt her with comments like, no, that's not what I asked you. Or as she was even still trying to answer the question, he would just talk over her. And so Judge Beverly got really irritated with him and addressed his behavior quite a few times during his cross-examination of various witnesses. Lally would also ask a question to her and she would say she doesn't know anything about that. And then he would continue to ask her questions about it, even though she already said she didn't know anything about it. And then he would later re-ask the same question. And this was another example or reason why Judge Beverly kept addressing his behavior. Dr. Russell also said that the only injuries she saw on John's body that looked like dog bites and dog scratches were on his arm. During the time that Mr. Lally or the Commonwealth presented their witnesses, it was always interesting to hear what cross-examination was going to bring out from these witnesses. And so I was hoping or expecting that same type of behavior once Mr. Lally or the Commonwealth cross-examined the defense's witnesses, but it really didn't happen. So it was kind of a letdown that we didn't get like a picking apart of the person's testimony. He really didn't have much to ask Dr. Russell, so he tried to catch her in lies from day 27 from the voir dire. And he tried asking her, did you write a report about what you saw? And she said no. And she had already said no, she didn't write a report about this because they were trying to get her to admit that basically the defense did have information on Dr. Russell and had a report about what she thought. And the defense just didn't turn it over to the Commonwealth for review before her testimony. And she again stated, I did not write a report. And he asked why she didn't. She said, no one ever asked me to write a report. And he tried to do this again with a couple other questions, such as her subscription to, I think it was called the Boston Post.
Yes.
This case, is that right?
Yes,
And how did you come upon it? You have a subscription to the Boston Globe?
I did at the time, yes,
Did at the time. What time was this?
in May,
May of 2024?
yes.
And how long had you had a subscription to the Boston Globe at the time that you saw this?
It was either a 6-month subscription or a year, I don't remember.
You subscribed to the Boston Globe online?
I did at that time. I have not renewed it.
How long had you been a subscriber to the Boston Globe?
Probably a year or 6 months, 6 months to a year.
Now, again, you had testified here just a couple of days ago when I asked you questions about this, is that right?
Yes,
It wasn't in your testimony just a couple of days ago that the subscription was actually for a year or 18 months. You
No.
remember, not 6 months a year.
Only one person can talk at a time. So was that your testimony, doctor?
no, I don't believe so. I believe that I said it was a 6-month subscription or a 12-month subscription.
And in any event,
So with that was the end of her testimony and cross-examination from Mr. Lally. And the next witness brought onto the stand was Richard Green. He owns and operates United States Forensic, which does forensics on data. He said he looked at John's phone to see when John got to 34 Fairview, and based off of his research of John's cell phone, he said that John was actually at 34 Fairview at 12:24 a.m. He also went into in-depth detail about how Jennifer McCabe's phone works when you're opening tabs to look on the internet or selecting calendar or anything else on the phone. And he said that Haas Long to Die in the Cold, that internet search, was done at or before 2:27 a.m. and that yes, it was deleted. He was asked if he had ever heard of spontaneous deletion, and he said no, he's never heard of such a thing. He said the user would have had to delete those searches and those phone call records themselves, that he had never heard of such thing as spontaneous deletion. When Lally was cross-examining Mr. Green, Lally tried to imply that Haas Long to Die in the Cold and How Long to Die in the Cold those two searches were done around the same time, and Mr. Green said no, they were not, and that they were actually done in two different tabs. So it wasn't like she tried typing it in and then as Jennifer had described in her testimony that Karen was yelling and stuff, and then so she typed and she kept asking how long does it take to die in the cold, and so then she looked up again. He said that these searches were done in two different tabs at two different times. So Mr. Lally asked him questions about how the Apple Health app worked on John's phone. And Mr. Green explained to Mr. Lally that he did the extensive testing trying to recreate those scenarios of how these steps were taken or created or read by the app. He said he sat down, he tried waving the phone to see if it would read steps at that point. He said no. He said he tried tossing the phone into the air towards the ceiling to see if it would create the 3-floor ascension and descension. He said it didn't. He said he put the phone in his pocket, he held it in his hand, and the only time it ever created steps was when he was actually stepping. He said he even tried moving the phone to be in the rhythm that he walks. It would not record a step taken in the app. So he said the only time it recorded any steps taken was when he was actually walking with the phone. And with that was the end of testimony for day 29. Please like, share, and subscribe and give me a thumbs up. I will see you back for trial day 30. Have a good night. Bye.